Hello everyone, a very good morning to all of you. Welcome to the Officers Adda. A very good morning to all of you. Welcome to the Officers Adda 24/7, the special session of your BRBL subject in the English medium language. Those candidates who are new in this session, as you know that today is 25th of August and from 1st of September your CIB registration date is going to be start. So guys, if you want to crack this exam now, first of all clear your all the concept of 5 subject, because 4 compulsory subject plus 1 is your elective subject, which is very important. And before registration you also have to select that which elective paper you have to give in the exam, because after registration you cannot change the elective paper. So that's why this is a time in which you can easily select the elective paper and do. As you know that if you just enroll in the CIB ka Mahapacks, so there is already recorded video courses of all the elective paper. So now it's your, capability that which elective subject is easy. In my opinion, if you just ask my opinion, so I would like to prefer you to select the HRM paper. Why you have to select the HRM paper? Because in this HR paper, almost 60% you people have covered the syllabus in ABM and ABFM. So that's why if you want to choose the elective paper, so this HR paper is one of the best one. So this is the only time in which you have to do something for the CIB exam. And do not think that, do not think that you have to crack this exam in 2 and 3 session. No guys, this is the only time in which you have to do something. Okay, now, so guys, we are doing the question and answer. So in today's session, we have to do the questions of what? Integrated banking. Integrated, it's not banking. Integrated Ombudsman. Its full name is Integrated Ombudsman Scheme 2021. This is a new act. Why this is a new act? Because see, this is the integrated. What is integrated? That is a compilation. Integrated is basically, that is the compilation of all the act, right? Compilation of the 3 act. So in this one, banking ombudsman has been merged, then NBFC has been merged, and the third one is your the payment system ombudsman has been merged. So 3 has been merged in this one CIB, this one integrated ombudsman scheme. Okay, now let's start with the question and answer. That is very important from the examination point of view. The first question on the screen is that, class. The first question is that banking ombudsman, what is written here? The banking ombudsman may award compensation. What is compensation, class? Compensation is basically, that is the monetary relief. What is compensation? It is basically the monetary relief. Okay, so banking ombudsman may award compensation not exceeding dash to the complainant for the mental agony and harassment. So you have to tell me that how much compensation they will give in the mental agony and harassment. So whether it is 1 lakh, 2 lakh, 3 lakh, 5 lakh, or none of the above. Tell me, class. And do not forget to like the session, subscribe the channel of Officer Adda 24/7. Yes guys, which of the following is the right one? This is very important, as we know that there are certain limitations. There are, class, certain limitations. Suppose ombudsman, in ombudsman this is up to 20 lakh. In Lok Adalat it is up to 20 lakh. And in the DRT it is 20 lakh and above. So this is exactly your this one. So tell me the right answer for this question. For the mental agony and harassment, how much compensation they have to give? And ombudsman is basically the this one, the authority that who have to give the. Yes guys, what is the exact answer? What is the exact answer for this question? So class, in this one, the right answer will be, that is 1 lakh. So 1 lakh is the right answer for this question. Okay, next. Next question is, the Banking Ombudsman introduced under dash of the Banking Regulation Act. So under which section this is added? Whether it is section 25A, 30A, 35A, 40A, none of the above. So you have to tell me the exact section here. You have to tell me the exact section here. Tell me class, under which section this, because see, the Banking Regulation Act is basically from the module A. This is basically from the module A. So what is the exact answer? So for the second one, the right answer will be section 35A. So C is the, for the second one, C is the right answer here. Okay, what will be the right answer? C will be the right answer here. Okay. Done class? Next. Next question is, the Banking Ombudsman is a senior official appointed by RBI to redress the consumer complaint specified under which clause of the Banking Ombudsman scheme? Clause 8, Clause 7, Clause 6, Clause 5. Banking Ombudsman is basically the senior official that is appointed by RBI to redressal the customer complaint. This is the exact definition of the term Banking Ombudsman, specified under dash of the Banking Ombudsman scheme. Clause 8, 7, 6, 5, what? What is the right answer? So for this one class, the right answer will be, that is clause 8. Okay, so clause 8 will be the right answer here. Next, how many banking ombudsman, what is this? How many banking ombudsman have been appointed? 10, 18, 15, 22. What is the right answer? Yes, class, how many banking ombudsman has been appointed, whether it is 10, 18, 15, 22, what is the right answer? How many banking ombudsman has been appointed? The banking ombudsman total is, this is 22. Okay, right now this banking ombudsman scheme 2006 has been removed, but still this is the part of the syllabus, so that's why we have to just see all this session. Okay, so 22 is the right answer. Next, the question is, class, which are the banks that is covered under banking ombudsman scheme, whether it is scheduled commercial bank, RRB bank, scheduled primary cooperative bank, all of the above or none of the above? Tell me, guys. Yes, class, which of the following is the right answer? Whether it's cover the scheduled bank, RRB bank, primary cooperative, all of the above. So for this question, the right answer will be D, that is all of the above. D is the right answer for this question. Okay, next. Next question is, the banking ombudsman charge dash fee for filing and resolving the customer complaint. 100 rupees, 200, 300, 500 or no fee required? Yes, class. Which of the following is the right one? The banking ombudsman charge dash fee for filing and resolving dash complaints. Which of the following is the right one? 100, 200, 300, 500, no fee. This is very simple and important. So if we talk about the fee, so this is no fee. Okay, no fee required. See, if we compare the court and the ADR system, right? So this court, that is take fees, procedure, technicalities they have to follow, but in ADR nothing will be happen. In ADR, simple, they can make their own procedure also. Okay, so that's why for the this one, E is the right answer. Okay, class, E is the right answer for this question. Next, is there any limit on the amount of compensation as specified in the award? 10 lakh, 18 lakh, 15 lakh, 20 lakh, none of the above. Tell me. Any limit on the amount of compensation as specified in the award? 10, 18, 15, 20, none of the above. Tell me the right answer for this question. Yes, class, any limit on the amount of compensation as specified? Yes, there is a limit of 20 lakh that we have already discussed. So this is the right answer. Okay, next. If compensation sought from the banking ombudsman is beyond dash, the banking ombudsman reject a complaint at any stage. Tell me, whether it is 5 lakh, 10 lakh, 15 lakh, 20 lakh and none of the above. Tell me the right answer. If the compensation sought from banking ombudsman is beyond dash, the banking ombudsman reject the complaint. What is the right answer? What is the right answer for this question? So if the compensation sought from the banking ombudsman is beyond, the banking ombudsman may reject the complaint if it is beyond 20 lakh rupees. So for the eighth one, D will be the right answer here. See? Okay, next. Ninth question is there. One can file appeal against the award or decision of the banking ombudsman rejecting the complaint within dash from the receipt of the award. Tell me class, suppose this is the banking ombudsman. They have given the award. Okay, award means that is justice. So we can just appeal to the appellant authority and in how many days? In how many days class? 25, 18, 15, 30 days or none of the above. Which of the following is the right one? So for this one, the right answer will be that is 30 days. So for the ninth one, D will be the right answer. Okay, this. If a complaint is not settled by agreement within the period of dash month, the banking ombudsman proceed further and award. Okay, the complaint is not settled by agreement. Agreement means the disputed party have just done the agreement, that through agreement they will solve the dispute. So tell me class, if a complaint is not settled by agreement within the period of dash month, the banking ombudsman proceed further to pass the award. So tell me which of the following is the right one. So for the 10th one, the right answer will be within 1 month. So 10th one, B is the right answer for this question. See class, in the banking ombudsman, what you have to remember, see, in every act now, when we were just studying in LLB, so we have to mug up the section, the important cases name, the fact of the case, etc. But in this, okay, but in this scenario, what you have to focus? You have to focus only on the concept clarity. So the concept is very, very much important. What actually the module C? So module C is basically, it's contain 10 act. So DRET and DRT is one of the important, act. In the DRT Act, the two tribunals are there, DRT and DRET. So first of all, we have to understand that what do you mean by the term DRT? As we know that for any dispute, the court is there, right? For any dispute, court is there. But court takes so much time. Court, we have to follow so much procedures, so much technicalities that court they have right now. So that's why we need a thing. We need a thing class in which we can easily say that the speedy justice will be given to us. So the speedy justice can be only given by the tribunal. So in the tribunal, we have to basically focus on one, DRT, because DRAT is the appellant tribunal in which we can appeal. Okay, so that's why this is very important to understand the basic difference between the DRT and DRAT. Okay, now let's start with the question and answer, which is very important from the examination point of view, right? So before starting this questions and answer, we will just do one by one. Okay, we will just do one by one question so that it will be very important for us. The first question is that, as you can easily see, that DRT Act is applicable if the amount is recoverable. What? Tell me class, the number one question. DRT Act is applicable only if the debt recoverable amount is what? Whether it is 15 lakh, 10 lakh or 20 lakh. What is the right answer? A very important one. As I have already told you, in Ombudsman, up to 20 lakh compensation that can give. Lok Adalat also up to 20 lakh they can give. So what is the exact amount of DRT. It is applicable only if the depth recoverable is above dash lakh, 15 lakh, 10 lakh, 20 lakh. So what is the exact amount? Tell me, class. And these questions are very, very much important. Yes. What is the exact answer? So as you know that in DRT, the exact amount is, that is rupees 20 lakh. So 20 lakh is the exact answer of this question. DRT is applicable only if the depth recoverable amount is 20 lakh. So first one, 20 lakh is the right answer. Right? This point is clear to all of you? Okay, next. Depth recoverable through DRT, it may be secured and unsecured. What do you mean by the term secured? Secured means, suppose if we have given any security, it may be of movable or immovable property, that is called secured. And unsecured means just like your personal loan, educational loan, in which we have not given anything as a security and we have taken the loan, that is called unsecured. So for the depth recoverable through DRT, it's maybe secured, unsecured. That is a true and a false statement. Tell me the right answer of second one. Yes, guys. Tell me the right answer of this second one. The depth recoverable through DRT, it's maybe secured or unsecured. That is true and false. This is very, very much simple. Secured, suppose if we have taken the loan. So the mortgage, pledge, these are the things that's come under the secured one, hypothecation, right? In which we are giving the security. So for the second one, the depth recoverable through DRT may be secured. This is absolutely true. It may be secured and unsecured both. So for the second one, true is the right answer. 3. Overdrawn amount in an account is not a debt recoverable under the DRT Act. That is true and false. Tell me. Overdrawn amount in the account is not a debt recoverable under the DRT Act. So for the third one, the right answer will be overdrawn amount in an account is not. This is totally false because overdrawn amount can also recoverable under the DRT. Okay, so this is false statement, right? If a civil court has passed a decree, it has to be executed through that court only and cannot come to the recovery tribunal. That is true because we know that the court is always there since from the Britishers' time. But DRT is there after the establishment of the Act in the 1993, right now. So before this Act, the law generally passed by the court. So suppose now in 1993 when the Act come into existence, okay, when the Act come into existence, so the tribunal has been made. So if any decision is given by civil court, because this loan problem or the this one security problem is not a one problem, right? So you have to tell me that in that case, okay, so whatever the decision that is taken by the civil court, so is that the right one? Tell me. If a civil court has passed a decree, it has to be executed through the court only and cannot come to the recovery tribunal. That's it. For the fourth one, the right answer is this is absolutely false because whatever the decision that is passed by the civil court, it have to be recovered by the tribunal also. So that's why for the fourth one, false is the right answer. Got it? Now, a bank has allowed a current account holder an ad hoc overdraft. Ad hoc means for the particular purpose of the 15 lakh. An amount is due. So whether this is recoverable under the provision of DRT Act? No, no, yes, yes. What is the exact thing? As we know that
the DRT amount is 20 lakh and above, but this is the ad hoc overdraft of 15 lakh. Ad hoc means for the particular purpose. So for the fifth one, whether A, B, C and D, which of the following is the right one? So for the fifth one, the exact answer will be yes, it is the legally recoverable amount by the bank. So for the fifth one, this C is the right answer. Okay, C is the right answer here. Done? Next. Next question is, DRT is established by which authority? Tell me, guys. DRT has been established by which authority? Tell me the right answer. Whether it is established by RBI, whether it is established by central government, or what will be the exact answer? Tell me. The DRT is established by, that is so simple. DRT is established by basically the central government. This is the right answer. Established by the central, this is government. So first one, this is the right answer. Central government is the right answer. Okay, now Debt Recovery Tribunal consists benches of 3 persons only. As we know that in India there are 39 DRT and 5 DRAT. So you have to tell me, Debt Recovery Tribunal consists the benches of 3 persons, because we know that in DRT class the highest person is presiding officer and their helpers are the recovery officer. So it is not in an exact number that how many recovery officer and will be there. So that's why we cannot say that. We cannot say that class, as you can see, it consists of the 3 members. So this is totally false. This is totally false. Okay, now jurisdiction of appellant tribunal is with respective high court. Jurisdiction of appellant tribunal is with the respective high court. That is true and false. Jurisdiction of appellant tribunal is with the respective high court. Tell me, class. Jurisdiction of appellant tribunal is with respective high court. The answer is false. Why? Because see, DRAT is the highest appellant tribunal. No matter can be forward after the DRAT. Okay, no matter can be forward after the DRAT, because DRAT is the highest appellant tribunal. That's it. Okay, now the next question is on the screen is that, can the order of central government in the appointment of the presiding officer of tribunal can be challenged in any court? It means whatever the decision that is given by the tribunal. Okay, so that decision can be handled, or you can say can be dealt with this one. Tell me. Whatever the proceeding that is going on, so it should be dealt with the court. It can be challenged in any court. Tell me the right answer. Yes, no, no, yes. Yes, before the appellant tribunal, no. No, unless High Court permit, and yes, the consti before the High Court. So the right answer will be absolutely no. This is the right answer. That's it. Okay. Now, tell me. The decree passed by foreign court can be executed by tribunal. A very good question. A decree passed by the foreign court can be executed by the tribunal. That is true and false. Yes, class. Decree means any decision which is given by the foreign court. So that can be executed by the tribunal. And this thing we have already done in the paid class. So if any decree that is passed by the foreign court can be executed by the tribunal, the answer will be absolutely, that is yes. So this is the right statement. True. For a certain valid reason, the chairperson of appellant can transfer any case from one tribunal to another tribunal within the jurisdiction, because we know that in India there are 5 DRAT and there are 39 DRAT. So specifically metropolitan cities plus Allahabad, that consists of DRAT, right? So you have to tell me that whether the chairperson of appellant tribunal, they can transfer any case from one tribunal to another tribunal within his jurisdiction. This is true and false. Yes, class. Tell me the right answer. For the second paragraph, the certain valid reason for chairperson of the appellant tribunal can transfer any case from one tribunal to another within jurisdiction. The answer is absolutely, that is true. This is the right answer. For the matter for which tribunals are empowered, the civil court having no jurisdiction. For the matter for which tribunals are empowered, the civil court have no jurisdiction. There are so many alternative methods of the court, just like your arbitration, conciliation, mediation, negotiation, etc. So why these alternatives have been made? The alternative has been made so that the matter can be easily solved by the ADR. We do not need to go to the court. So for this third point, if any matter for which tribunals are empowered, the civil court have no jurisdiction, this is absolutely true. This is absolutely class true. If so, see, if tribunal have done any matter, if a tribunal have given anything, okay, any decision, if suppose if every matter will forward to the court of tribunal, then what is the existence of the tribunal? What is the authenticity of the tribunal by giving this decision? So because of that reason, that is happening. So for this one, true is the right answer. Okay, guys. So this is the right answer. Next. This is the last paragraph, but that is very important question. DRT jurisdiction for a bank is where head office of the bank is located. Head office of the bank is located. That is true and false. So DRT jurisdiction for a bank is where head office of the bank is located. This is totally false. No. If a bank has filed the recovery application, other bank can join the application if the defendant in say bank 1, bank 2. A person have taken loan from this, not able to pay the loan. Bank 1 filed the case in DRT. If the same party is there, same subject matter is there, so bank 2 can also file the case on the same DRT. They can also join the matter. They can also merge the matter. Okay. So for the second one, If a bank filed the recovery application, the other bank can join the application if the defendant is same. The answer is true. Absolutely true. Okay, now when a case gets transferred from civil court to tribunal, the court fee is required to be paid. A very good question. Third one. When a case gets transferred from the civil court to the tribunal, the fresh court fee is required to be paid. The answer is very, very simple. That is totally false. No need to require to pay the fees. The counterclaim. What is a counterclaim? Filed before DRT has the same effect. See, in any case now, if one party filed the case, that is called plaint. If another party is giving the reply, that is called counterclaim. So the counterclaim has the same effect just like the plaint. That's it. Understand? Since DRT is not a civil court, it cannot pass interim orders such as attachment, injunction, receiver, etc. Since DRT is not a civil court, it cannot pass interim order. This is totally false because interim order means the mid order. That is not the final order. But DRT can pass. A person who has to file appeal before appellant tribunal has to pay. If a person file before the appellant tribunal, he have to pay 50% of the amount. This is the right answer. Right? And the next one is, tell me, while filing appeal before the appellant tribunal, if any amount is required to be deposited, so tell me class, how much amount they have to require to be deposited? Right now we have just done the question, right now. So they have to be deposited what? How much amount? They have to be deposited the amount that is 50% of the amount that is required to be deposited at the time of filing the appeal. So this is the right answer.
Almost completed the module D part, okay, and module D part we have completed. Then module C, only 2 days are left. We will just finish this module C also. So after that B and A, and then we are going to start the definition portion of your act. So that's why this session is going to be very, very, important from the examination point of view. Now this limitation act, what exactly the limitation act? So this is basically that what is the time limit for filing any case. What is limitation act? That what is the time limit for filing any case, and this limitation is applied to every suit, for every application, and for every appeal. This is very important. For every suit, every application, every appeal, this limitation act is important. Okay, and in the tax law we basically have to understand income tax, we have to study GST, commodity, direct tax, and your PAN card. So these are the content that we have to study in the tax law. So this is your complete package. Okay, now let's start with the question and answer of the session. Number one question on the screen is that, guys, that what is the period of limitation for filing a suit for compensation for breach of the partnership agreement? Breach of the partnership agreement, this question you can understand in the two way. Suppose a person is there and this is the partnership firm. So they are doing they do business with each other. So they just breach the partnership agreement. Suppose if a person breached the partnership agreement, so in that case, partnership firm have in how many days, that within what time limit they have to file the case? This is the question. within what time limit they have to file the question. So whether it is 1 year, 2 year, 3 year, 6 year. Yes. So this is very much important. Okay guys, what is the right answer? Tell me. This is the first situation. The second situation, in which suppose the partners are there, P1, P2, P3. If the partnership agreement is reached by suppose this person, so we have to file the case for the compensation. So what should be the time limit? Whether it is 1 year, 2 year, 3 year, 6 year. Tell me class. This is important question. This is important question. So the right answer is, guys, that is 3 years. 3 year is the right answer. And please give the answer as much as possible. Okay? This is the right answer. Next. The next question is the limitation period for filing a suit for possession of movable property by person dispossessed. So in that question, what is possession? What is ownership? So possession is basically what? Suppose this land is mine. This land is mine, right? But I have given this land to my friend. So it means I have given the possession of the land to my friend, but the real owner is Nikita ma'am. So suppose class, if any person who have a movable property dispossessed, suppose in ownership also I have my possession, I have my ownership. Suppose if X person have taken my property, so what is the time limit in which I can file the case on the movable property? What is the time limit in which I can file this? What is the time limit? 1 year, 3 year, 6 year, 12 year. What is the right answer here? So guys, if we talk about the movable property now, so for the movable property, always remember the limitation is 3 years. 3 years is the right answer for the movable property, because every property, whether it is immovable, movable, each have a different limitation period, and these types of questions come in your exam. So okay, this is the right answer. Next. Now class, in this question, in the suit for recovery of possession of immovable property based on title, if the plaintiff has been dispossessed, the period of limitation is, now class, in this question, this is of immovable property. This is of immovable property. Now tell me the exact answer. Yes class. For the immovable property, whether it is 6 year, 12 year, 30 year, or what? That is very important question. That is very important question, guys. So for immovable property, always remember this 12 year is the right answer. Third, B is the right answer. Okay, 12 year. Done? Now, next question is the limitation period for filing a suit for specific performance of the contract in the case containing breaches calculated from the date of, what is specific performance of the contract? Suppose in any contract, we do not demand the compensation. We just need only that material which is breached. Because normally in contract, we just demand the compensation. I think that is okay. But for the specific performance, suppose if you have taken a very precious item, if you just broke it, I want my only that property. I don't need any compensation. That is means I need a specific performance. So for specific performance, if you are continuing breached the contract, so that is calculated from the last breach, from the first breach, recovery of the breach, and none of the above. Tell me the right answer. The limitation period for filing a suit for specific performance of the contract in which the continuing breach is going on, so that will be calculated from the, this is first one, calculated from the first breach. So fourth one, B is the right answer. Okay, next. What is the period of limitation for filing a suit for recovery of possession of the ancestral property by the co-sharer? Co-sharer means, suppose grandfather, the property will become to the father, grandfather to father to son. That is called ancestral property, that comes after the death of that person. So if ancestral property, suppose the co-sharer is there, father, brother is there, 3 brothers are there. So now this is the property. This is the property. Now tell me, what is the limitation period for the ancestral property? Suppose if anyone breach that contract. So for this one class, if the ancestral property is there, the right answer will be 12 years. A is the right answer, because for ancestral, that is basically the immovable property, and for the immovable property, this is 12 years. Okay, next. The next question is that what is the period of limitation for suit relating to immovable property for the foreclosure class by the mortgagee? Foreclosure by the mortgagee. So what is the right answer? Foreclosure. Tell me. For the foreclosure, the right answer will be, that is 30 years. And what is foreclosure? Foreclosure means basically, suppose, what is mortgage? B person is there, this is bank. If the bank have given 15 lakh rupees and this B person have given the immovable property to the bank, in that case, bank first of all dispossess this property from B person, and after dispossess, the bank will sell the property. So this is called the process of foreclosure. So the limitation is always 30 years. See, the limitation is always of 30 years. That's it. Okay, guys. So this is the right answer. Done? Next. The law of limitation only bar remedy. It means that after 3 years, after 12 years, after 30 years, if you just approach to the court will say just get lost because my remedy is finished, but does not extinguish the debt, right, property, recovery. What is the right answer? The law of limitation only bar the remedy, but does not extinguish the what? Debt, right, property, and recovery. What is the right answer? Debt, right, property, recovery. So the right answer is class right. Suppose in the breach of contract, 5 lakh loss is there. So in that 5 lakh loss, I know that after 3 years, my remedy will be finished, but it's my 5 lakh. It's my right to take my property. That's it. So, right is the right answer. Now, tell me the answer. The limitation for filing a suit by a surety against the principal debtor would be 3 years from the date on which, tell me, from the date on which amount was paid by the surety to the creditor, the date of demand by the creditor for the payment to the debtor or the surety, whichever is earlier, the amount become payable to the creditor, the refusal by the principal debtor to pay the amount of notice being by the surety. What is the right answer? And for this question, I think you people know what is contract of guarantee. This is principal debtor, this is creditor, this is surety. So what is contract of guarantee? If principal debtor is not able to pay the money, then surety will pay the money to the creditor, and after that surety can demand from the principal debtor. This is exactly the contract of guarantee that is given in section 126 of the Indian Contract Act. Okay, so the question is the limitation for filing the suit by the surety against principal debtor. Surety against the principal debtor would be 3 years. It means the limitation is 3 years, that within 3 years surety have to file the case. It means surety can demand the money from the principal debtor, right? So now you have to tell me when this will be start. The amount was paid by surety to the creditor, the date of demand by the creditor for payment to the debtor or surety, whichever is earlier, the amount become payable to the creditor, and the refusal by the principal debtor to pay the amount on the notice being the surety. What is the right answer? What is the right answer for this question? Tell me, guys. The answer is very simple. The right answer is when the amount that is paid by surety, after that this will happen. So this is the right answer. This is the right answer. Next is period spent in prosecuting the case before consumer forum can be. Period spent in prosecuting the case before consumer forum can be included, excluded, partially excluded, partially included. What is the right answer for this question? Tell me. Included, excluded, partially excluded, partially included. What is the right answer for this question? So we have already learned when we just read the Limitation Act that there are so many days that will be excluded in the Limitation Act. So filing of case, the date on which the judge will give judgment, or the time in which we just take the order, etc., that will be excluded. So this is the right answer. Next question is, in computing the period of limitation for an appeal, the day on which judgment pronounced shall be excluded, the day on which judgment pronounced shall be included, the time taken for preparing the decree be included, the day on which judgment pronounced and the time requisite for obtaining copy of the decree shall be excluded. What is the right answer?